In this episode, we talk about the details of an environment assessment report which reveals how the Uttarkashi tunnel collapse and its complicated rescue operation could have been avoided. We also talk about how 5 men constructed fake toll booths on a national highway in Gujarat. But first, we talk about the Gyanvapi Mosque case. Hi, my name is Rahel Philipose, and you're listening to 3 Things, the Indian Express news show. For several decades now, the Gyanvapi Mosque in Varanasi, which stands adjacent to the historic Kashi Vishwanath temple, has been at the center of multiple legal disputes between Hindu and Muslim devotees. For context, the mosque was built in 1669 during the reign of Mughal Emperor Aurangzeb, and the Hindu petitioners claim that he ordered the demolition of the pre-existing Vishweshwar temple at the site, replacing it with the mosque. And for years now, Hindu and Muslim petitioners are at odds over who has the right to worship on the premises. While the Muslim side argues that the mosque was built on Waqf premises, the Hindu side argues that it was built on the site of an older temple. The decades-old litigation around the mosque gained momentum about a year ago when 5 Hindu women sought the right to worship Ma Srinagar Gauri on the outer wall of the mosque complex. This case has now resulted in the Archaeological Survey of India conducting a scientific survey of the premises, the report of which was submitted to the Varanasi District Court just a couple days ago. This week, however, the Allahabad High Court delivered a considerable blow to the Muslim side once again while it was hearing a different case. In fact, the oldest running case in the dispute. The High Court dismissed 5 petitions put forth by the Uttar Pradesh Sunni Central Waqf Board and the Gyanvapi Mosque Committee, challenging a 1991 suit seeking the restoration of a temple at the mosque site. The Indian Express's Asad Rehman, who covers Uttar Pradesh for the paper, breaks down the case for us.
So the latest case to see an order on Tuesday is actually the oldest case, which was filed in 1991 during the peak of the Babri Masjid Ram Janambhoomi dispute. So the 1991 case basically, like the other cases, lays claim to the Gyanvapi Mosque and has said that the mosque is not legal and that it is constructed on top of a temple belonging to Lord Adishwar. So that is what the basic dispute between the two parties is, that while the Muslim side says that there is no evidence to back this and that this suit is barred by the Places of Worship Act.
The Places of Worship Act that Asad just mentioned was promulgated in 1991 during the height of the Ram Temple movement in Ayodhya. It essentially prohibits the changing of the religious character of any place of worship from what it was on the 15th of August 1947, meaning that if a place was a mosque on that day, it will remain a mosque, and if it's a temple, well, it will remain a temple. The Allahabad High Court dismissed the 5 petitions, holding that the original 1991 title suit that Asad mentioned earlier is not barred under provisions of the Places of Worship Act. The court also set a 6-month deadline for the completion of proceedings in the 32-year-old case before a Varanasi court. Asad joins us in this segment to talk about the Gyanvapi dispute, what the court has said, and what could happen next. So Asad, can you start by talking about this 1991 case? We know it's the oldest case in the Gyanvapi legal dispute, but why is the Allahabad High Court hearing it now?
So this particular case, the one which was filed in 1991, it was lying unheard since 1998. Which is more than 23 years. And now after this issue came into the limelight a couple of years ago when there was another case which saw the commission of a survey and other aspects. So after that, fresh application was filed in this case and Allahabad High Court started hearing it.
Right. And why did the High Court decide to dismiss the 5 petitions by the Muslim side?
The Allahabad High Court has said that the Places of Worship Act does not define the religious character and it only defines conversion and place of worship. So essentially what the court is saying is that if the religious character in 1947 that has to be established, then for that there needs to be a hearing and that the evidences have to be collected on whether on 1947 this place was a mosque or a temple. So that is what the Allahabad High Court is relying on. And this has also been in the past said by the Supreme Court. And that's what the Allahabad High Court has also said. And I'll now just quote a bit from the High Court order. What will be the religious character of the disputed place can only be arrived at by the competent court after the evidences are led by the parties to the suit. It is a disputed question of fact, as only part and partial relief has been claimed of entire Gyanvapi Mosque, which comprises settlement plot numbers 9130, 9131 and 9132. Now, this is what the Allahabad High Court in its order on Tuesday has said, basically establishing that the religious character on what it was in 1947 is something that has to be looked into, and once the evidence is collected, only then can it be decided what the religious character of a place was in 1947.
Okay, so Asad, what's next for the Muslim petitioners in this particular case? Could this be the end of the road for them?
Frankly, there are no options now, because the Supreme Court has also, in Gyanvapi case at least, they've also said that these cases are not barred by the Places of Worship Act. So they don't have a higher court to go to now. And in the separate case, which is the Rakhi Singh versus others case, the ASI has already submitted a 1500-page report to the Varanasi Court, District Court, with whatever they found. That report has not been released to the media or to anybody so far. And the contents of that report and the kind of evidences that are presented by the Hindu petitioners and the Muslim petitioners, that is what will decide the course of this dispute in the near future.
And Asad, we've been seeing cases like these play out in several parts of UP over the years, right? Starting with Babri Masjid in Ayodhya to the Shahi Idgah Mosque in Mathura more recently. What are the commonalities between these cases, and what are the kinds of concerns that they raise?
See, the common aspect in all these cases is that the Hindu petitioners or the Hindu plaintiffs are claiming that these structures, which are established mosques, are on top of temples which are built, which were there pre-Mughal era. Now, their claims are that, like the Babri Masjid and the Ram Janambhoomi dispute in Mathura as well, there is Lord Krishna's birthplace where this Shahi Idgah Mosque was built. Similarly, in the Gyanvapi case as well, it's the same claim that the mosque was built by the Mughal rulers after destroying a temple. So the cases are very similar in nature. The relief sought by the Hindu side is also very similar in all three cases. And the Babri case is obviously now concluded with the Supreme Court holding that the land must be given to build a temple. And then these two are also, the cases are similar in nature. Now, whether the outcome is going to be similar in nature or not, we don't know that. But at least the cases and the trajectory of the cases seems to be very similar so far. Now, in Mathura as well, a survey is going to be conducted on orders of a court by a commission. Similarly, a survey was first conducted last year in the Gyanvapi Mosque complex, where the shivling or the fountain, the Hindus claim it is a shivling while the Muslims claim it is a fountain, was found inside the mosque, and the Hindus saying that it's a symbol of Hindu religion and a temple within the mosque complex. So now let's see where the Mathura case and the Gyanvapi case go. But for now, it does seem similar to how the Babri case progressed initially.
And next we talk about the Uttarkashi tunnel collapse. Last month, 41 workers were trapped for a total of 17 days inside Uttarakhand's Silkyara Barcode tunnel, which had partially collapsed. The rescue had proved to be challenging, facing multiple setbacks. According to official records, over 650 people were involved in the rescue operations, but ultimately it was rat hole mining, essentially manual drilling, that successfully extricated the trapped workers. But now, an environmental impact assessment accessed by the Indian Express reveals that this entire situation could have been avoided. And this is because early on in the project, the option of building a separate escape tunnel was ruled out by those involved. In this segment, my colleague Shashank Bhargava speaks with Jay Mazoomdar of the Indian Express, who broke the story for the paper.
Jay, could you explain why was it proposed that a separate escape tunnel be built into the structure? There was no recommendation. These are certain design options to choose from at the planning stage of the tunnel. So depending on the proposed length, twin duct is one of the standard options, which is one main tunnel for regular traffic and a narrower parallel tunnel for evacuation in an emergency. We have different standards, but many countries like Japan, they opt for a twin tunnel design when the length exceeds 3 kilometers. Silk-Era Barcode tunnel was 4.5 kilometers long.
And what was the reason that this idea was eventually ruled out and they did not end up building this?
Building two tunnels costs more and takes longer than constructing one. That was their main ground for ruling out the separate evacuation option. And for some reason, the project considered only vehicular collision under various scenarios of risk and disaster. And I did not find a mention of potential tunnel collapse as one of the risk factors considered. So the reports say that they did not anticipate high volume of traffic high up in the hills. So that was another ground they did not think a separate evacuation tunnel was necessary.
And so in the eventual structure, did they end up incorporating anything that could provide an escape route to people?
No, not in a situation where, as we have seen, there was a total lateral collapse of a part of the tunnel. In that scenario, whatever option they had would be useless because at the planning stage, their proposal was that instead of a separate tunnel, they will have a dedicated lane, which would be marked by a divider for evacuation in case of fire or vehicular collision. So the recommendation was to have a 7-meter lane for two-way traffic and a 3.5-meter lane for emergency escape within the same tunnel. Again, a tunnel collapse was not one of the risks they considered. But during construction, even this was modified. So they did away with the separate channel for evacuation. So instead of a 7-meter channel for traffic and 3.5-meter channel for evacuation, they made one divider in the middle of the 12-meter tunnel. And they said that this was done to segregate the traffic. So one-way traffic would reduce the chances of collision and it would be safer. And they kept some gap in the divider. So the idea was that if there was an accident or fire on one lane, the other lane could be used for evacuation. So again, there was no real consideration of a situation when the entire thing can come down the way it collapsed last month.
And you have been speaking to experts and engineers about this. What do they have to say about the fact that this risk was not considered?
Yeah, I mean, off record, quite a few of them have spoken and they pointed out that total blockage, a total lateral collapse like we had last month, in that case, wherever you put the divider, whether you leave a 3.5-meter channel or you put it in the middle, it becomes quite redundant because only a separate evacuation tunnel could have helped in such a situation. Or there was another option they pointed out, which was not considered at all, where you have a few lateral inclined escape adits. I mean, something which goes up to the ground surface at some regular interval through the tunnel so that if there's a blockage on either side, you can come out on the surface using those. So only these two could have helped in such a situation. And for whatever reason, we know that the cited cost and time overrun, they did not think these were necessary.
And Jay, besides this, in the past, you've also reported that there were other red flags as well when it came to this tunnel, including those related to geological challenges that the tunnel might face. Could you talk about them a bit?
Yeah, I mean, this area is, we all know that it's, I mean, the terms now which has become almost cliched, like, the Himalayan, the fragile Himalayan geology. It's a young mountain. There are many fault lines across, but specific to this area where this tunnel was coming up, in the detailed project report of this segment of the Char Dham, and the report said that the alignment was very unfavorable in two segments of the 4 segments. So half of the alignment was not favorable. And it also added that the possibility of forming wedges in the crown and sidewall. Crown is the ceiling and could not be ruled out in those two sectors. So 50% of the length of the tunnel was tricky. And they said that special care would have to be taken during construction. And this was in 2017 before the work was commissioned. And as recently as in this August, one of the project consultants also pointed out that from the beginning of the tunnel driving excavation, the geological conditions proved to be more challenging than was predicted in the tender documents. And the challenge and the geological risks involved, these were flagged repeatedly for the last 3-4 years.
And Jay, the other striking thing about this project has been how it managed to get an exemption from environmental clearance that are necessary for projects as big as this. Can you explain how exactly it managed to do that?
Yeah, I mean, this is one issue which was highlighted many a time before for this particular master project, Char Dham project, which was conceived to improve connectivity between the four holy places in the hills of Uttarakhand. It's nearly a 900-kilometer wide and long project, but it was broken down into 53 civil works, I mean, short stretches, to make use of an exemption from environmental clearance, which was offered to all road or railway projects which are under 100 kilometer in 2013. And then the idea was that if the project is not too long, then it did not go through the entire process of an assessment, the risk assessment, EIA, environmental impact assessment process, and it will avoid delay. But this project was broken down to meet a very ambitious deadline. Initially, only 2 years were rationed for it. It has been extended since. And put it briefly, in 2019, the Supreme Court formed a committee, and which committee asked the Char Dham project to do a rapid EIA because it was late and already work was on. Then again, instead of doing a cumulative EIA, an EIA of the entire Char Dham project, what it did was conduct smaller EIAs of the segments of different legs, and that defeated the purpose. I mean, if you have a small leak in a large tank, you may not worry as much about the loss of water as you would if you measured the total loss through 50 small holes simultaneously. That's how the system of checks and balances was defeated. After the incident, experts now hope that the government will reconsider the strategy.
And in the end, we talk about how 5 people constructed fake toll booths on a national highway in Gujarat. Earlier this month, the Gujarat police dismantled 2 fake toll booths and filed charges against 5 men, including the Sarpanch of a village, for building fake toll booths on both sides of the National Highway 8A. When we spoke to the Indian Express's Gopal Kateshiya, he told us that NH8A is an extremely busy highway in Gujarat.
This highway basically connects Saurashtra region and Kutch region with the rest of Gujarat and onward to the central India and the southern India. So it's very busy highway, and it's busier also because of the fact that it's one of the roads which connects Kandla, the largest public sector port of India, as well as Mundra, the largest private sector port of the country. So it's very busy.
And Gopal says that this highway cuts through a village called Vaghasya. And in 2010, when the National Highway Authority of India, or NHAI, established the toll plaza, they had permitted the villagers from Vaghasya to use a dirt road next to the highway as a way to bypass toll payments. But soon this information spread among regular commuters, and they started using the dirt road as well. And this is when a few locals from the village had an enterprising idea.
Because they saw an increase in the traffic on that dirt road, and they said that because those vehicles were passing through their village, why not make use of that? Because in any case, those vehicles were generating a lot of dust.
He says that 5 people from Vaghasya began stopping vehicles on the dirt road, charging a toll of 50 rupees for trucks and 10 rupees for cars. And Gopal came to know that this proved advantageous for the commuters, since the official toll amount was significantly higher, between 110 to 720 rupees, depending on the size of the vehicle. Moreover, the collectors of this illegal toll would claim that the money was for building temples in the village.
During my investigation, people showed me at least 4 temples in the villages, and they told that these temples have been built from the fund. They call it Phalo in Gujarati. So they said that these temples have been constructed by using those funds. And villagers also showed me a cricket ground with a cement concrete pitch and with a boundary wall around it, saying that this cricket ground has also been developed from that fund.
Now, what is remarkable is that this fund collection had been ongoing for nearly a decade. However, in December of last year, another such illegal toll plaza came up on the other side of the road. And this time it was situated inside a defunct ceramic tile factory called the White House Tiles Private Limited. And this was what first got the attention of the NHAI officials.
They saw an increasing decline in the number of vehicles passing through the toll plaza since December last year. And so the people who were manning the NHI's toll plaza noted that a lot of vehicles are entering the White House factory, but not all of them are stopping there. They are just using the factory premises and exiting through a west gate, which falls right on the National Highway 8A. So they complained to the NHAI. NHAI eventually complained to the district administration of Morbi, and police got involved. So that's how they got suspicious. They lodged complaint, and eventually the police took action.
He says they subsequently filed an FIR against 5 individuals, including Dharmendra Singh Zala, the Sarpanch of Waghasya village, for allegedly forcing motorists to bypass the NHAI toll plaza and extorting money from them.
Dharmendra Singh Jala is also husband of Varshaba Jala, who was the president of Wakane Taluka Panchayat, which is a local body ruled by the Bharatiya Janata Party. And Dharmendra Singh's father Badhu Singh was Sarpanch for 20 years of Waghasya village. So he's an influential guy. His brother Yuvraj Singh has also been named as an accused. And other accused includes Amarshi Bhai Patel, alias Amarshi Vasjalia, who is son of prominent Patidar leader Jairam Vasjalia. Jairam Vasjalia's family owns this White House Tiles Private Limited, the ceramic factory which shares its border with the NHI. So those people have been named in the FIR, but police say that officially they are all on the run. There has been no detention, no arrest. So investigation isn't progressing. In the meantime, Dharmendra Singh Jala, the Sarpanch of Waghasya, and his brother approach Morbi District and Sessions Court seeking pre-arrest bail, but the Session Court has pressed the application. So that is the status of the investigation.
During reporting on the case, when Gopal visited the illegal booths, he noticed that private security guards employed by the NHAI and police constables were manning the now closed entry and exit of the plazas. And he says that since then, the official toll plaza saw an uptick in both the volume of vehicles passing through and the amount of toll collected.
The number of vehicles crossing that toll plaza increased by around 1,500, and the daily toll collection has increased by around 5 lakh rupees per day.
But Gopal tells us that villagers who are still allowed to use the dirt road have mixed feelings about this entire issue.
There is a lot of sympathy for these people, Dharmendra Singh and his brother, and what the other people were doing, saying that, these people were helping out poor occasions like marriages. They also constructed one shed in the perimeter of the village. So they do enjoy goodwill of the villagers. But a few villagers also told, on the condition of anonymity, that it's good that this illegal passage has been shut and no heavy vehicles are flying through the village. And the reason is that earlier those vehicles were generating a lot of dust because this was a dirt track, and that was causing a lot of problem to those who were living on the either side of that dirt track. So they say that it's been shut for good. So there are two ways, but large majority support the accused.
You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar. It was written and produced by me, Rahel Philipose, Shashank Bhargava, and Utsa Sarmin, who originally spoke to Gopal Kateshiya for the 3rd segment. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone who you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Podcast and write to us at podcast@indianexpress.com.